Password's right here.
On your
Good
right-hand
morning.
side.
It is 9 o'clock. We're going to go ahead and get this show on the road. My name is Carrie Ann Farrell Hines. I'm the chair of the Legislative Committee of the California Board of Accountancy. Good morning to our members and to everyone who's here in attendance. I would like to start by taking roll. So can we start with our member at the end of the table here to my left?
Dan Jacobson.
Carola Nicholson.
Luz Molina.
Deirdre Robinson.
Carrie Ann Farrell Hines. With that, we have a quorum. I'd like to start off by reading.
I'm Kathleen
Oh,
Wright.
I'm sorry, Kathleen.
You have to move closer.
Oh, you want me to move closer?
Yeah.
Okay.
No, I'm kidding. I'm kidding. You were,
But I just want
that
you
was
to know
my
I'm
own.
here, so if you need one more for a quorum, you got one more.
Thank you very much. I apologize. That is that's the problem with my own vision, even though I'm wearing glasses. I'd like to start our meeting again by saying thank you again for everyone for being in attendance. And I'd like to read a statement about the tablets that you see up here. You may notice that committee members may be referencing tablets during the meeting. The tablets allow the members to more easily access meeting materials and are not being used to discuss, deliberate, or take action on any item within the board's jurisdiction. I would also like to make a statement about public comments. In order to allow the CBA sufficient time to conduct its scheduled business, public comment will be limited to 5 minutes. Please make your comments focused and relevant to the duties of the CBA. It is not necessary to repeat statements or views of a previous speaker. It is sufficient to state that you agree. Written statements should be summarized and submitted to the CBA. They should not be read. The board values input from the public as part of its consumer protection mission. It invites and welcomes public comment during this section of the agenda. However, board members cannot engage in dialogue with those who testify during this section of the agenda due to constraints imposed on the CBA and its members by law. The law prohibits the CBA from substantively discussing or voting on any matter brought up during public comment. A member of the public who would like to seek the CBA to discuss a general topic not related to a specific case involving one of its licensees can ask the board to consider placing the issue on the board's agenda for a future meeting. If you have an application or disciplinary charges pending before the CBA, we ask that you do not discuss the details of your case or pending complaint, since the board members will be the judges and by law are not permitted to receive evidence or information that is not part of the administrative record in the case. And at this time, I'd like to move on to our first item on the agenda. And we'll begin with item number 1, which is approval of the minutes of the July 20th, 2017 Legislative Committee meeting. And at this time, I'd like to ask if any member would like to make a motion to adopt the minutes.
I make a motion that the minutes be adopted.
Thank you. And can I have a second? Thank you, Ms. Wright. Are there any additional comments or discussion from committee members on this item? Seeing none, are there any comments from the public? I will now call for the vote. Ms. Reed, can you please call for the vote?
Carrie Ann Farrell Hines.
Yes.
Absent, sorry. Dan Jacobson.
I abstained because I think I wasn't on this committee last time.
Luz Molina Lopez.
I abstain.
Deirdre Robinson.
Yes.
Kathleen Wright.
Yes.
And Carola Nicholson.
abstain.
The motion passes. All right, thank you very much. I'd like to move on to item number 2, which is discussion and possible action on proposed legislation. And at this time, I'd like to invite Mr. Franzella to please begin your presentation.
Thank you. Good morning. So for this item, the CBA is being asked to approve the proposed legislative language to amend Business and Professions Code Section 5100 and to direct staff to seek inclusion in the 2018 Omnibus Bill, or if necessary, seek an author to carry the legislative bill. At your meeting in September, members clarified their position regarding Business and Professions Code Section 141, which is Attachment 1 to your materials. Inasmuch as the CBA affirmed its position that for disciplinary or other actions taken by other agencies, certified copies of the events documented in the record the disciplinary or other action shall be considered conclusive evidence. So in attachment two to your materials, staff worked with DCA legal counsel in the AG's office and prepared the draft legislative language for members' consideration. The language includes not only certified copies, but true and correct copies, recognizing that some agencies may not actually formally certify an order, but their orders are available as a public record on their website. The language notes that the CBA would rely on the facts and events contained in the order, and then would consider any rehabilitation, aggravation, or mitigation criteria offered by the licensee. However, the licensee would not be allowed to impeach or challenge the findings of the prior final agency decision. So staff at this time would recommend that the CBA approve the proposed legislative language in attachment 2. And at this time, I'm happy to turn it back over to the chair and answer any questions members may have.
Thank you. Can we go with questions first and then a motion, or should we have a motion and then questions?
You could do either way.
All right, so I'll open it up to questions from the committee members, if you have any on this item. So seeing no questions, would any member like to make a motion based upon the recommendations made by Mr. Franzella today?
So moved.
And can I get a second?
A second.
Thank you. Are there any additional comments or discussion from committee members?
Yes. I know that last time we decided that to make the recommendation regarding certified copies. And that now, as you mentioned, we've added true and correct copy. The certified copy has the either inked or embossed stamp of the particular government agency. And in court, you don't need someone to stand to get up on the stand and say, I swear that I'm the custodian of this, and I'm going to, and these are in fact the copies. That's what the certification does in court. True and correct copy. I sign things all the time where I affirm to the court that something is a true and correct copy. And I'm not a government. And I don't think that we should rely on, for a conclusive presumption, meaning no one can argue about what happened, we should rely on me. I don't think we should rely on me. A certified copy, we had that discussion last time. That's something where a particular government is saying something. It's not me saying something. And I think that there's a qualitative difference between the two. And so I don't think that the motion should pass, because I don't think that true and correct copy is appropriate. If we get a true and correct, anyone, signs something under the penalty of perjury or swears to it, that something is a true and correct copy for a government, from Russia or from North Carolina or from North Korea or from Nevada or whatever. I don't think that anyone, us or any of the licensees, should be bound by that. Certified copy, it's a different story. So I'm going to vote no.
I'd like to recognize that Mr. Sani has joined us at the table. Do you have comments that you'd like to offer?
Yes, this addition was put in to frankly facilitate the element of identifying the correct copy or an actual copy. And as Mr. Jacobson said, often certified copies are readily available. In some situations, however, let's say for the PCAOB, they're not easily certifiable, but the PCAOB posts all of its decisions right on the web. They're independently verifiable. So in any case in which we have a piece of evidence submitted into a proceeding, that evidence can always be refuted. So if in fact it's certified, it is what lawyers call self-authenticating. That is, you don't need to have anyone testify. If in fact it is certified, you may need to have a declaration, as Mr. Jacobson appropriately stated, that says that this is in fact a true and correct copy of the official record. But in the case of that, in that situation, the other side can simply oppose it and say, prove to me that it's a true and correct copy. And then you have to go through the elements of proof. This happens in court proceedings all the time, where a party says that isn't a true and correct copy. The document says that there's 3 exhibits to it, and your copy doesn't have the 3 exhibits to it. Or they pull it from the web and it's different. And so that's a risk that the agency has. But in every case that I've dealt with over the last, 3 or 4 decades, if you obtain a document, whoever is going to testify that it is a true and correct copy is going to verify it, and it is subject to being refuted, as Mr. Jacobson said. So if an agency such as the CBA goes into a hearing and can't establish that it's a true and correct copy, then they're going to lose. They're not going to be able to establish that. But we believe in most cases these are independently verifiable documents. The PCAOB, by the way, is the agency that we kind of had in mind because they're not easily obtainable, yet every firm that I've dealt with will not dispute that they post their decisions on the web, just as the SEC does, and they're independently verifiable. The judge can verify it, the opposing counsel can verify it, and it's never been a subject of dispute. So it's that limited issue that is addressed by this language. In most cases, the agency will get a certified copy, but there are occasions where, for mechanical reasons, it becomes difficult. But these are usually not subject to any evidentiary dispute whatsoever. And it's the agency that's bearing the risk. Yes.
May I
I'd
ask
like
a
to
question?
recognize Ms. Wright.
Thank you. A quick question. I tend to agree with you. My only question would be, how much of a delay would there be if we limited the submission to a certified copy? Could that cause a delay in the proceeding?
Yes, it could cause a delay if in fact, you end up getting, the agency for whatever reason is just delayed. They've got a backlog, it takes them 3 or 4 months to process a certified copy, and that can really prejudice. Meanwhile, it's actually on the web. And I've had agencies who say it is on the web. And we have rules of evidence that govern these proceedings that allows for documents to be that are for the court to take judicial notice of documents from other agencies, and it is done by declaration by counsel all the time.
May I ask you just an informative question, which is, in these proceedings that we engage in here, do you actually use the California Administrative Procedure Act as the basis for the evidentiary requirements?
Yes, and it gets supplemented by the California Evidence Code as well.
Okay, then I'm
And so
okay.
the administrative law judges are sensitive to this issue. By the way, you often have cases, for example, let's say we take the testimony under oath of a licensee in the investigative stage of a proceeding, and we show them a copy of the PCOB order, just a copy. And we ask them, is this a true and correct copy? Is this the order that disciplined you before the agency? And they say, yep, that's the order. Well, this language that's being proposed would say, if the other side has admitted under oath that this is a true and correct copy, we don't have to go through the mechanical process of delaying the hearing so that we can get a certified copy of a document that they're not even disputing, that they've admitted is their disciplinary document and is posted on the web by the agency in question. So it's really a convenience factor. We really don't think that there will be any prejudice whatsoever. And the only party that bears any risk here is really the agency, not the respondent.
Mr. Jacobson, can I take Ms. Molina, please, first? Ms. Molina?
Yes, thank you. Quick question, the majority of these copies, would they be found on the web? Is that how we would receive them?
Yes.
They're all
Yes.
from the web?
Yes, the Securities and Exchange Commission posts all their decisions on the web, and the Public Company Accounting Oversight Board does the same. And you can literally reach it by Google on any specific decision in a matter of seconds. And these are, again, I've had agencies who've asked me, why are you requiring us to go through the trouble of certifying this? They're all on the web.
Right. So for ease of use, it's already available now. We need to
Correct.
know.
And if there's
Should
any
that be sufficient?
dispute about it, again, it's the agency that bears the risk, not the respondent.
Thank you.
Mr. Jacobs?
I'd be fine with as you described, if this was a rebuttable presumption, could be refuted. But that's not what the language says. It says, in causes for discipline against a licensee under certain subsections, the board shall rely on the findings of events stated in a certified or true and correct copy of the disciplinary or other action as conclusive evidence for the purposes of determining discipline. So this language elevates true and correct copies to the exact same status as a certified copy. If we wanted to, again, I'd be fine with it being with true and correct copies there being a rebuttable presumption. That's not a problem, but that's not what this says.
Yeah, sorry, go ahead.
I think a certified copy still has to be identified, it has to actually have a true stamp. So before you even get to the issue about whether it's conclusive or not, you first have to establish that it's either a certified copy or a true and correct copy. You can certainly refute that it is a certified copy. You can say, Your Honor, that is not actually, that stamp is not from the agency, or it's not a proper stamp. So you can refute and rebut, if you will, that it's a certified copy, and you can rebut that it's a true and correct copy. But once you establish those preliminary facts that this is a correct copy of the disciplinary decision, then the conclusive effect goes into place, which again, just for those who may not have been here, this is simply the CBA's legislatively approved use of Business and Professions Code Section 141B. So 141 allows for these other types of orders to be given conclusive effect. Then in 141B, which is attached, the legislature said the agencies can adapt this rule to their own specific requirements and needs, which is what this statute is intended to do. Simply an implementation of 141 as the legislature contemplated for the agencies to employ.
Just a final thought is that, and I understand what you're saying about you can say that's, they emboss them, they don't stamp them with ink, and you bring in proof about that. But you've got there's a presumption that has to be overcome. In any case, the true, if these things weren't different, they wouldn't be different. There would just be one thing called a certified / true and correct copy, and they are different. The certified copy has more power than does the true and correct copy. It is admissible. It is no one has to testify as to it. You'd have to go through great lengths to rebut that it is in fact a certified copy. A true and correct copy, well, now we've got to figure out if it really is a true and correct copy. You've got to have someone testifying. You've got to, and someone's going to have to. Well, if someone wants to rebut it, then they have to bring in the evidence to try in fact to rebut it. If the true and correct copy were the facts contained therein were a rebuttable presumption, and there are basically two kinds of presumptions, conclusive and rebuttable, then I'd be fine with this. But to elevate true and correct copy to the same as the conclusionary effect of a certified copy, I think is incorrect.
Mr. Franzella, and then I'll recognize Ms. Wright.
I'll defer to Ms. Wright.
All right, Ms. Wright?
Oh, okay, thank you. My only comment would be that in an administrative forum, the technicalities of and the formalities of the courtroom process are dispensed with in order to provide for an expedited proceeding that is simpler and able to be handled actually by the individual themselves if they choose not to have a lawyer. That being the case, my question then goes to Carl, that is what we're doing with certified and true and correct and accepting either one on an equal basis for the purposes of our deliberations, consistent with the APA and the evidence code?
It's entirely consistent with both the APA and the evidence code. In fact, in the evidence code, there's a specific mechanism. Mr. Jacobson is correct. A certified document is what we call self-authenticating. It testifies as to itself. No one actually has to say a thing. You just plop it down, and the court says, yep, that's certified, and I accept it. The true and correct goes through one additional step, which is someone has to testify that, in fact, it is a true and correct copy, but it is done all the time. There's an actual evidence code section, I believe it's 452, that allows a person to say that this is a true and correct copy and request judicial notice of the fact that it is true and correct. And they do this because certain types of documents are really very easily verifiable. And just to increase the costs which, by the way, would get charged to the respondents in these cases, to go through this process of getting a certified copy is just unnecessary. So even in whatever case you're dealing with, whether in litigation, in court, or in administrative context, a good portion of the documents we deal with are true and correct copies.
Okay.
Mr. Franzella?
So I'd just like to point out, with more agencies going to online for accessing the data, one of the things that when we added this language, it keeps us from having to come back later and amending it if the agencies stop doing certified records as a general practice, or if it gets so elongated to get the certified record. So I believe this leaves the flexibility to the board. We would still be, as Mr. Sani pointed out, we're still be required to prove up that it's a true and correct copy. Staff would either testify or file the declaration, or both, in that matter. So I believe this gives that flexibility to the board, and as Mr. Sani said, we bear that burden adhering to prove this up. So if it's not a true and correct copy, we're not going to be able to rely on it as conclusive evidence. So I just wanted to make sure the board has some flexibility as it goes forward and not has to amend this as maybe more agencies start going online and requiring or requesting agencies to then download it from a public source. So.
I'd just like to add that I think it's important to keep note of the fact that this is an effort to streamline, not, overly streamline, but to streamline some of the processes of the disciplinary process that the agency uses in order to protect the public. So this is a detail within that process, and as Ms. Wright pointed out, the streamlining of the process does have the effect of benefiting both sides, because we do want to find ways to allow the licensees not to be caught in circumstances in which they're overly burdened with having to defend themselves in disciplinary actions. But I think the point that Mr. Franzella just made about the enforcement department being mindful of not taking advantage of licensees and their lay person's understanding of the rules and regulations, and ensuring that when presenting their matters to the board, that they are also protecting the rights of the licensees during these matters and their due process rights. I think that's an important thing to note, and I appreciate that Mr. Franzella is bringing that to the attention of the board, so that we, as the judges in these matters, can also be aware that we have to also protect the rights of the licensees in defending themselves in these actions. So I'd like to, are there any other comments or questions from other members? Would any member like to make a motion on this matter? I'm sorry. Okay. And we have a second. So if there are any additional comments or discussion from committee members? Are there any comments from the public? So I'll now call for the vote. Ms. Reed, please call the roll.
Corolla Nicholson,
I approve.
Kathleen Wright,
Yes, approve.
Deirdre Robinson,
Yes.
Luz Molina Lopez,
Yes.
Dan Jacobson,
No.
and Carrie Ann Farrell Hines.
Yes. So the motion carries. Thank you, Mr. Franzella and Mr. Sani, for assisting us with this matter. I'd like to move on to Agenda Item 3, which is a discussion and possible action on proposed legislative language to amend Business and Professions Code Sections 5095C, providing attest services, and 5130 application fee. Ms. Mobasaki, please begin your presentation.
Good morning, Madam Chair and members.
morning.
Thank you. The purpose of this item is to provide the CBA with information regarding proposed language for inclusion in the Senate Committee on Business Professions and Economic Development. I will refer to this committee as the BMP, their annual omnibus bill. As you may know, each year, the Senate BMP Committee provides an opportunity for the Department of Consumer Affairs boards to submit non-substantive and non-controversial proposals for consideration in an omnibus bill. During a review of the Business and Professions Code, staff identified 2 sections the CBA may wish to consider making a non-substantive change that would assist in clarifying and updating current law. Business and Professions Code Section 5095 establishes the attest experience requirement for CPA licensure applicants who wish to be licensed with the authority to sign reports on attest engagements. Subsection C contains language that is no longer applicable. Specifically, it states, quote, "An individual who qualified for licensure by meeting the requirements of Section 5083 shall be deemed to have satisfied the requirements of this section." Section 5083 was removed from the Accountancy Act as it pertained to experience requirements for CPA licensure that existed prior to January 1st, 2010. Staff proposed deleting the language in subdivision C and reordering subdivision D as identified in attachment 1. If you turn to attachment 2, you will see Business and Professions Code Section 5130, which requires the CBA to collect a fee from CPA applicants and states, quote, "The board shall charge and collect a fee from each applicant for the certificate of certified public accountant. The fee shall accompany the application, which must be made on a blank provided by the board." To add clarity and consistency with our statutes and regulations, staff proposed changing the word blank to form. Staff recommend the CBA adopt the changes to Business and Professional Code Sections 5095C and 5130 as identified in the attachments, and to direct staff to seek their inclusion in a 2018 omnibus bill, or if necessary, seek an author to carry a separate bill. This concludes my presentation, and I'd like to turn it back to you.
Thank you very much. Is there any discussion or comments on this matter? Would any member like to make a motion?
I move that the non-substantive changes be recommended as stated.
Thank you. Can I get a second? Thank you, Ms. Wright. Are there any additional comments or discussion from committee members? Are there any comments from the public? Seeing none, I will now call for the vote. Ms. Reed?
Okay, Carrie Ann Farrell Hines.
Yes.
Dan Jacobson,
Yes.
Luz Molina Lopez,
Yes.
Deirdre Robinson,
Yes.
Kathleen Wright,
Yes,
and Corolla Nicholson.
Yes.
Thank you, and with that, the motion carries. Thank you, Ms. Mobasaki. So I will now move on to agenda item number 4, and that is public comments. Are there any public comments at this time? The chair recognizes a member of the public.
I'm wondering if this is the meeting, or should I wait till 12:30?
This is the meeting of the Legislative Committee of the Board of Accountancy. So this is not the full Board of Accountancy that's present here. Would you like to make a comment at this time?
Is it 5-minute public comments or not?
This is the public comments portion of the Legislative Committee of the Board of Accountancy. So this is for public comments for this committee's business.
And this is for laws?
Legislative, yes. Would you like to make a comment at this time?
Well, I'm wondering if it should be here or in the afternoon committee.
Ms. Bowers can assist you if you have some questions.
Thank you.
Ms. Bowers, should we just give it a moment? All right.
Maybe 5 minutes?
All right. We'll just take a break. We're not going to adjourn. So we're okay. So if there are no other members of the public wishing to offer comments at this time, I'd like to move on to ask, are there any agenda items for our next meeting? Seeing that there are none, this meeting is adjourned. Thank you.